Good day, my name is Luzibo and I am an artificial intelligence presenter. Today we are discussing the proposed amendments to the Termination of Pregnancy Act in Zimbabwe, as outlined in the Medical Services Amendment Bill 2025, including the changes, their significance, and key points of public debate. The Termination of Pregnancy Act, Chapter 1510, was enacted in 1977 during the colonial era and considered very restrictive. It currently allows abortion only in limited circumstances, mainly when the pregnancy endangers the woman's life or physical health, and requires certification by medical practitioners and judicial oversight. The Medical Services Amendment Bill 2025 proposes to rewrite key parts of TOPA to modernize reproductive health law and align it with Zimbabwe's 2013 constitution, broader health standards, and human rights commitments. The National Assembly passed these changes on the 23rd of October 2025. The bill is now before the Senate and must receive presidential assent before becoming law. These are the core changes proposed. Expanded legal grounds for abortion. The current law has very narrow exemptions, generally requiring threats to physical health or life and judicial sign-off. New proposals would allow abortion on request up to approximately 12 weeks gestation without needing to cite risk factors. Termination up to approximately 20 weeks where there is risk to a woman's health, mental well-being, or socioeconomic stability. This represents a significant broadening of lawful grounds, in contrast to the older Act's narrower categories. 2. Simplified access. The previous law required approvals from magistrates and multiple medical practitioners, procedures that advocates say delayed care and pushed women toward unsafe abortions. Under the new bill, such judicial bottlenecks would be eliminated, and only informed consent from the pregnant person would be required in most lawful cases. Example, the requirement for magistrate approval, historically blamed for tragic delays, would be removed. 3. Autonomy of pregnant persons, including minors. The bill proposes that only the pregnant woman's consent is required, even for minors under 18. Prior rules allowed guardians or parents to override a minor's decision. Parental or guardian consent would no longer be a legal barrier. This reflects a shift toward bodily autonomy principles and constitutional rights to health and dignity. 4. Expanded provider base. The proposal would allow trained midwives, particularly in rural and under-resourced areas, to provide abortion care under specified conditions, addressing provider shortages. 5. Alignment with constitutional and human rights frameworks. Proponents argue the reforms would bring Zimbabwe in line with constitutional rights to reproductive autonomy and health, Section 48 of the Constitution, international commitments such as the Maputo Protocol and Sustainable Development Goals, particularly maternal health. Additionally, recent High Court rulings have found parts of the old TOPA unconstitutional, especially regarding mental health exemptions, reinforcing the need for legislative reform. Supporters of the amendment argue based on public health and rights rationale, stating that the 1977 law is outdated and contributes to unsafe abortions and preventable maternal deaths. Secondly, simplification of access is expected to reduce delays and unsafe procedures. Thirdly, recognizing mental health and socioeconomic factors reflects lived realities for many women and girls. Advocates frame the bill as a rights-based public health reform that supports women's dignity and constitutional freedoms. However, many religious groups, moral leaders, and some politicians have publicly warned against the proposed changes. The Zimbabwe Christian leaders claim the amendments expand abortion access too broadly and threaten sanctity of life norms. They argued that the bill was introduced with insufficient public consultation and could undermine moral and cultural foundations. Some voices raise concerns that looser mental health clauses or informed consent rules might lead to very broad access, including in later stages of pregnancy, or be misused. Catholic legal groups have also contended that certain clauses are unconstitutional or improperly introduced. The bill was passed by the National Assembly on the 23rd of October 2025 and is now under review by the Senate. If approved by the Senate and signed by the President, the bill will become law and replace portions of the 1977 Act. Meanwhile, ongoing public debate continues in civil society, religious bodies, and legal circles on both moral and technical grounds.